first tip is really thinking about, in many cases, of seeking claims, at least in the first instance, claims of intermediate scope. I remember when I first started out in practice, I mean, there's different schools of thought, but I did work with some people who said, look, we just need to have as few words as possible, and when we'll get that first rejection, that will help guide us towards an outcome. But at least for me, over the years as I've built portfolios, I've really come to realize that that can be really counterproductive. Instead, when one really thinks about what does the client really need, even what does the client need for that first patent application, that can be very helpful in ensuring that one seeks protection and scope descriptors that are really going to be valuable and frankly more palatable to patent examiners. So consider intermediate scope as a possible first step, recognizing that you can then in continuing applications essentially seek broader protection. But don't underestimate the value of a longer term strategy. Next tip is really being very mindful of claim drafting that is really squarely focused on what is ultimately going to target the proper party. How many times, I don't know if this has happened to you, where you're at the point of possible enforcement or assessing possible enforcement of issued patent claims, or hopefully claims that have been issued within the last 2 years so you can file a broadening reissue. But how many times have you seen that where you've studied your own patents or studied other people's patents and realized that there are multiple entities in this value chain, manufacturing chain, use chain? So I can't say enough the importance of really thinking about that proper infringer and testing the assumptions with the clients. You may have a first draft, but really in a pinpoint fashion, really pushing the client to make sure that the work product you are delivering is actually going to be enforceable. Because if it's not, you're just ultimately, you've spent a lot of money, the client's money, and the value proposition is just going to be totally destroyed once the reality is made clear. Next, really thinking again the longer term view when you're drafting patent application specifications. So this is really, again, thinking about and beyond what is in front of you, adding additional embodiments, thinking about the potential implications of the technology, how might things change. Obviously, for example, for Section 101, that's a whole nother aspect that we need to build in as we're trying to build flexible applications that can support claims that can potentially allow us to target infringers at a later date. Really thinking more broadly again than what is before us.